Reaction by PH.
So, ayan po, magandang araw po sa inyong lahat. Luzon, Visayas, Mindanao. Ayan, ay pag-usapan naman po natin ngayon ay patungkol sa discussion ni Attorney Abayon. Ayun, na mali daw ang sinulat ni Justice Leonel ng Korte Suprema patungkol sa impeachment na lumabas ito ay lahat po ng mga grado natin sa sa Korte Suprema ay naging unconstitutional ang kanilang sagot sa impeachment ni Vice President Sara, no? So, yun po, ang nagsasabi dyan ay halos lahat naman po ay yung mga pro-impeachment na gusto makonvict si Vice President Sara, no? So, yun po, i-discuss ni Attorney yung desisyon ng Korte Suprema at kayo na po ang bahalang humusga, no? Pero sana po, kahit na po ganun, tanggalin po muna natin kung kayo po ay pro Duterte o pro-impeachment para po malinawagan natin kung tama po ang kanyang explanation ni Attorney Bayon, no? So, kayo na po mismo ang humusga. Ang pinapaano ko lang po sa inyo, wag niyo pong wag po tayong bias para maliwanagan po natin kung tama po siya. So, kayo na po bahalang humusga, no? At ngayon po sana, kung bago lang kayo sa ating channel, huwag niyo pong kalimutang mag-subscribe, mag-like sa ating channel at doon po sa baba ng ating video ito sa kanan, pindutin nyo na po yung ating logo para makapag-subscribe, ano? So maraming salamat po sa mga lahat ng nag-subscribe. Sana po panoorin nyo po hanggang dulo para maliwanagan tayo at kayo na po mag-comment na lang po sa ating channel. So huwag nyo na rin pong kalimutan mag-subscribe kay Attorney Neil Abayon, no? Ito po, sabay-sabay na lang po natin panoorin.
So ito po kasing case, medyo mahaba po talaga to, 97 pages. So hindi ko na lang iisa-isahin talaga pag flash yung mga relevant provisions. Pero explain ko na lang po yung mga legal principles na natutunan ko dito at kung ano yung in-explain mismo po ng Supreme Court para po mas mabilis at dire-diretso yung usapan at discussion natin kasi masyado po tayong mapapahaba kung iisa-isahin ko talaga tong lahat ng mga highlights ko. Okay, pero anyway po, yung most important dito is mag-start po yan around page 56. Okay, so this one.
So, ayan po. Ang naging sabi niya, i-discuss niya rin po kung ano po yung unang violation. Nakalagay, first clear violation. Yun. So, panoorin po natin. Ano?
In-explain din po yan dito talaga sa decision pero ipapakita ko na lang din sa House rules nila mismo. So kung makikita po ninyo, ang nangyari kasi or yung articles of impeachment na pinadala dun sa Senate is yung in-endorse by at least 1/3 of all members of the House. So this one po, makikita ninyo, Rules of Procedure in Impeachment Proceedings, House of Representatives, 19th Congress, Rule 2, Initiating Impeachment. So nakalagay po yan sa Section 2, Mode of Initiating Impeachment. Impeachment shall be initiated by the filing and subsequent referral to the Committee on Justice of ABC. Okay, so makita po nyo yung tatlong modes of impeachment po na nakalagay sa Constitution as required and provided by the internal rules ng House mismo, lahat yon kailangan pa rin i-refer sa Committee on Justice. So yung pinaka-specific provision po na kailangan natin dito intindihin talaga is itong letter C, a verified complaint or resolution of impeachment filed by at least 1/3 of all members of the House. So ito po yung ginawa ng House. So ang nangyari dito, diniretso nila yan sa Senate. Pero according to their own internal rules, kailangan pa yan filing and subsequent referral to the Committee on Justice. Okay, so kung makita po ninyo, dyan pa lang, they violated already their own.
So, ayun po, no? Yung in-explain po ni Attorney, ito po sa bagay, no? Basta kayo na lang po bahalang kasi ako po kasi nung pinapanood ko yan yung sa Senate, sa plenary nung August 6, ganyan po din ang sinabi ni Senador Marcoleta, no? So, Pero sinabi naman niya po na kahit siya ay maka-Duterte noon sa ano, pero ang ano niya, nakasidiretso lang po siya. Hindi siya, yung time na siya ng plenary yun, diretso po ang kanyang tingin. Hindi siya pro-impeachment, hindi siya pro-Duterte. Ganun po, ano.
Internal rule. At kung makita po ninyo yung citation dito ng House of Representatives, itong number 1, they based it on the decision in Francisco et al. Versus House of Representatives. So ito po yung basihan ng provision nila. The landmark case of Francisco, yet dito po sa pag-refer sa Committee on Justice, hindi po nila yan nagawa dun sa impeachment complaint endorsed by 1/3 of all members and dun din po sa first 3 impeachment complaints. Okay, so yan pala po, makikita natin that's a mistake already, a clear mistake already on the part of the House of Representatives. So this one was also discussed in the Supreme Court decision po. Okay? And sinasabi ngayon ng mga pro-impeachment, yung gusto makonvict si VP Sara, wala naman daw ganung requirement for due process na nakalagay sa Constitution or in the past cases po of impeachment. So again, this was heavily discussed dito in the later pages of this decision. Pero yung sinite at inexplain lang din po yan dito ni Justice Leonen na nakalagay yan actually sa internal rules po ng House of Representatives. So ipapakita ko po ulit sa inyo. So again, Rules of Procedure in Impeachment Proceedings, House of Representatives, 19th Congress. So ito yung binasa natin kanina, di ba? Rule 2, Initiating Impeachment. After po niyan, yung next. So ito po, Rule 3, Finding Probable Cause for Impeachment. So this is basically the due process na inexplain ng Supreme Court dun sa decision. Yun po mismo, may procedure na nilay down po yung 19th Congress for that. So A, Committee Proceedings. Una-una po, i-determine muna nila kung sufficient informed ba. Kasi of course, it has to be a verified complaint. And then after dyan, i-determine nila kung may sufficiency in substance ba. In short, kung meron bang laman yung kaso na fina-file or is it just for the sake na manggulo lang or mag-file lang ba. And then after po dyan, kung makita ninyo in Section 6, Notice to Respondent and Time to Plead. Diba? So dito po sa internal rules pa lang ng House, meron na silang requirement na may opportunity talaga mag-explain and defend himself or herself yung isa pong impeachable officer. Pero this one was not all done by the House of Representatives. Ang nangyari nga, like what already stated, after endorsement of 1/3, diniretso na nila i-refer at ipadala agad sa Senate. Wala na po lahat to, hindi na to nasunod. Pero this is all the internal rules of procedure po ng House of Representatives when it comes to impeachment proceedings. So ito pong lahat ng sinasabi ko, hindi lang ako po yung nakakita nito. Even in the Supreme Court decided case po dun sa sinulat ni Justice Leonen, lahat po to sinulat niya rin to dun. Ina-explain ko na lang sa inyo ng dire-diretso para hindi na tayo mag back and forth po. Kasi madami pong citations and footnotes kasi dun eh. Okay? So kung makikita po nyo dito, nakalagay Section 6, Notice to Respondent, Time to Plead. If the committee finds a complaint sufficient in form and substance, it shall immediately furnish the respondents with a copy of the resolution and or verified complaint as the case may be, with written notice that the respondent shall answer the complaint within 10 days from receipt of notice thereof and serve a copy. So within 10 days po from notice ng respondent, kailangan siya mabigyan ng opportunity to file her answer. Yan po yung somewhat similar to a counter affidavit in regular criminal cases, diba? So again, makikita natin there is a due process requirement in the internal rules po ng House of Representatives mismo. So baka isipon nyo, gawa-gawa ko lang tong rules na to ha. Ilalagay ko po yung link, yung download link nito mismo sa description sa YouTube video po. So titingnan po nyo yung pinaka-header niyan, House of Representatives, Rules of the House of Representatives, 19th Congress. So ito lahat pinagbasihan lang din po to ng Supreme Court dun sa decision nila. So 'di ba, 19th Congress, Rules of Procedure in Impeachment, and so on and so forth po. So ito po yung next natin dyan is yung pag-trigger na ng 1-year bar rule. Pero before that, i-explain ko lang din yung sa procedural side of things kasi yun yung medyo controversial at magulo kasi sinasabi po ng iilang mga legal luminaries at yung mga members ng House at yung mga pro-impeachment ay hindi daw dapat ina-apply retroactively yung mga rules na nilay down dito ng Supreme Court because it will, kasi bago daw po siya. I have already explained that in my past video, di ba? Na unang-una in the Ombudsman Gutierrez impeachment case, it was already declared by the Supreme Court there na when it involves mga rules of procedure, procedural matters of impeachment, it is still treated in the same manner or in the same way as a regular procedural law in the sense na it can apply retroactively. Okay, that has already been decided po by the Supreme Court. So because of that, in-explain ko rin to sa past video, ilalagay ko lang din po yung link ng video sa description box, na therefore mag-a-apply ngayon yung general rule na it can apply retroactively subject to certain exceptions only. Okay, and yung 3 exceptions po na yan, like what I've already explained po in my previous video, unang-una po dyan, kung yung batas or yung decision nakalagay mismo na hindi siya pwede mag-apply retroactively. Pero dito po sa decision na to, walang nakalagay na ganon, and as a matter of fact, in-apply nga talaga nila retroactively, kaya dineclare nila as unconstitutional and void ab initio po yung 4th impeachment complaint. Okay? Tapos yung pangalawang exception po dyan at yung pangatlong exception is if it will impair vested rights, and pangatlo, if it will create an injustice. So yung number 2 at number 3 exception, isasabay ko na lang po ng explain yan kasi somewhat related po yan silang dalawa. So basically, ang point po doon sa number 2 and 3, procedural laws, procedural matters cannot apply retroactively kung meron ng mga karapatan na na-establish, tapos pag i-apply mo, mawawala yung mga karapatan na yon. Okay? So if we apply it to past impeachment proceedings, yung bagong rules na ganito, ano po ba yung mangyayari? Okay? Kayo po sumagot, mag-isip muna kayo ng konti, taong bayan. Of course, it will create or it will impair vested rights and it will create an injustice kasi yung mga past impeachment complaints, there were already full conclusions as to the issue dun po sa mga kasong yon. Okay? So ito po, bigyan ko kayo example, yung kay former Chief Justice Corona. Ano ba yung nangyari dun? He was actually convicted, diba, sa impeachment case dun sa Senate level. Therefore, yung right ng taong bayan na na-convict dun si Chief Justice, former Chief Justice Corona, is already a vested right, diba? So hindi mo na pwede i-apply yun doon kasi mawawala ngayon yung right natin na na-convict po si Chief Justice Corona doon. So doon, that is very clear na there will be impairment of vested rights. So hindi po yan pwede i-apply doon. Okay? And another example po, yung kay former President Erap naman, ano ba nangyari doon sa case niya? Kay former President Erap, he was not actually convicted in the impeachment trial. Yung decision po ng Supreme Court doon is that he was deemed resigned daw due to the events that transpired, yung EDSA 2. So doon po makita ninyo yung karapatan ngayon na na-vest or na-establish or nabigay po kay former President Erap is yung karapatan niya na hindi po siya na-convict sa isang impeachment. So kung i-apply natin yun doon, basically parang hindi pala siya nakalaya doon sa impeachment complaint niya, 'di ba? So it will create an injustice and impair vested rights po dun kay former President Erap and dun po sa taong bayan naman in the case of former Chief Justice Corona. So dyan pa lang po makikita natin na minsan siguro yung ibang legal luminaries natin na nabablinded sila by maybe political bias or political fanaticism. Kaya yung mga ganito pong basic principles of law natin, like what I've already explained, ito pong ina-explain ko, tinuturo to sa first year or second year law students sa remedial law 1 pa lang, itong principle po na to ng retroactivity of procedural matters. Okay? Anyway, going back po, siguro po nabubulag sila sa political bias, sa political fanaticism, tapos nakakalimutan na nila yung basic principles of law. So I just like to clarify that kasi nagko-complicate po yung mga bagay-bagay, mas gumugulo. Pero it is very clear naman po sa basic principles of law natin na hindi yun siya ganun. And as a matter of fact, the general rule is that rules of procedure can apply retroactively subject nga to dun sa 3 exceptions na in-explain ko, which is kung yung batas or decision mismo nagsabi na hindi mag-apply. Number 2, if it will impair vested rights. And number 3, if it will create an injustice. Okay? So hopefully klaro po yan. So anyway, hopefully po sana nakita nyo or nagets nyo po talaga yung point ko na pagtanggapin po natin or i-apply natin yung logic na gano'n na if they will apply this retroactively, therefore it should apply to all past impeachments, tapos magiging void na yung mga past impeachments, that will really lead to a very absurd situation. Kaya nga may general rule and exceptions as to the retroactivity po of procedural laws natin. So pag i-apply po yan dito sa case ni Vice President Sara Duterte, of course there is yet no vested right and it will not create an injustice because unang-una, si VP Sara has not been acquitted naman po sa impeachment. Pangalawa, hindi pa po napakonvict ng taong bayan si VP Sara. Therefore, there is no vested right of acquittal or conviction given to the parties, diba? So dun po palang makikita natin na pwede i-apply retroactively talaga dito sa pending case ni VP Sara itong bagong rules po na nilay down ng Supreme Court. Okay, so hopefully klaro na po talaga. Medyo paulit-ulit na ako dito pero yun din po kasi paulit-ulit na linalabas po kasi ng mga ilang legal luminaries natin, and I cannot just be silent about it because again, like what I have reiterated multiple times, those are very basic principles of remedial law na even a first year law student already knows, diba? So yun lang po ang gusto ko talaga i-emphasize dito. So in summary po dito sa decision na to, yung pinaka nag-trigger talaga or one of the main factors that triggered the 1-year bar rule dito is because of the deliberate inaction po on the part of the Secretary General dun sa pag-action niya or pag-refer niya dun sa first 3 impeachment complaints. So yung sinight po dito ni Justice Leonen and even din dun din po sa concurring opinion ni Justice Hernando, yung numerous interviews na kinonduct kay Secretary General Velasco na sinabi at inamin po niya mismo na sinasadya daw niyang hindi niya nire-refer pa yung articles of impeachment, yung first 3, kasi meron daw mga congressmen na kumakausap sa kanya na antayin daw muna kasi nagpe-prepare pa sila ng sarili nilang impeachment complaint. So lahat po yan, nakalagay po yan dito sa decision and makikita po nyo yan sa news outlet as cited here by the main decision and the concurring opinions. And because of that statement po, dun ngayon nagkaroon ng deliberate inaction which constituted as grave abuse of discretion as per the Supreme Court. Kasi dyan po papasok ngayon yung legal principle na what you cannot do directly, you cannot do indirectly. Okay? Kasi in this case po, ang hindi po natin pwede gawin lahat directly is mag-file or mag-initiate po ng more than 1 impeachment complaint within a period of 1 year. But due to the actions po dito ng Secretary General, he is now indirectly trying to circumvent that provision para po hindi niya matrigger yung 1-year bar rule. So dun pa lang po makikita ninyo na it can really be argued, and actually as a matter of fact, it was declared by the Supreme Court as grave abuse of discretion po yung ganong action ng Secretary General. So yun yung ina-explain ko way back before pa, diba, noong February, na because of that specific provision sa internal rules ng House, it can really be abused kasi may extra power na ngayon yung SecGen at Speaker. Tapos doon pwede nila madribble-dribble yung impeachment until the time na gusto lang nila i-refer. So yun po constituted as grave abuse of discretion on the part of the House of Representatives according to the Supreme Court. So again, more or less po, that can be argued na it falls under the legal principle of what you cannot do directly, you cannot do indirectly, diba? Because that will violate basic fairness, equity, and justice po sa batas natin. Okay? So yung pinaka main point po nung principle na yon, kasi ganito lang po yan, in Tagalog, kahit po may gawin kang isang bagay na mukha siyang tama o legal pero ginagawa mo yon to circumvent a provision, pwede pa rin yan siya ma-strike down ng Constitution. Yan po yung nangyari dito, di ba? Kasi yun nga po, bawal mag-initiate ng more than 1 impeachment complaint, pero dahil po dito sa deliberate inaction, dun po sa pag-dribble-dribble, na circumvent nila yung violation ng 1-year bar rule, therefore yung epekto nun ngayon, parang na-trigger na rin pa yung 1-year bar rule because of that circumvention or yung pag-iwas-iwas nga dun po sa direct provision of the 1-year bar rule. Okay? So ulitin ko lang po, what you cannot do directly, you cannot do indirectly. Alam po yan ng courts natin, alam po yan ng batas natin because that falls under the principles of justice, fairness, and equity. Diba? In short, dapat patas po tayo. Kung alam nyong kalokohan yung ginagawa nyo, alam din po yan ng korte. Basically, in other words, yung pinaka main point niyan. And of course, kung alam ng korte na mali yung ginagawa nyo, they will decide against that, which is dito, yun nga po yung ginawa ng Supreme Court. Yung deliberate inaction po on the part of the House of Representatives constituted as grave abuse of discretion, which in effect triggered the 1-year bar rule. Diba? So kahit na anong iwas po ninyo, but if you are trying to circumvent the law, matitrigger at matitrigger pa rin po yung gusto ninyong iwasan. Okay? Is because kung titingnan daw po natin yung constitution natin, there is really a sense of urgency na upon filing of verified complaint, dapat aksyonan agad ng House of Representatives. Tapos sinabi ng Supreme Court dito actually, tama naman na nasunod daw na na-file pala within the 10 session day requirement yung first 3 complaints. However, due to the deliberate inaction pa rin, kahit na nasunod yung 10-day requirement, yung 10 session day requirement, it still constituted nga po as grave abuse of discretion because of the reasons I already explained earlier. Tapos yung example po na sinight nga nila dito, di ba, final po nung December yung first 3 complaints, and then nung January biglang si Congressman Manuel of Kabataan Party List nag-privilege speech po siya kung saan ina-encourage po niya yung, or inaano po niya, basically pinupush niya yung House of Representatives para i-endorse at refer na yung first 3 complaints. Pero despite that privilege speech, wala pa rin pong ginawa yung Congress. Nag-inaction pa rin sila. There was still a deliberate inaction on their part. So dahil dyan po, that is another reason na kung bakit bakit there was deliberate inaction because it violated the sense of urgency ng Constitution na once filed nga dapat ma-refer agad at umandar agad yung impeachment process. So kung makita po nyo, madaming examples na binigay yung Supreme Court dito kung basahin nyo po talaga yung decision. So ito po ina-explain ko na lang in my own words, mas sinisimplify ko para mas madali po ninyo ma-visualize kasi yung iba pong wordings dito ni Justice Leonen I must admit medyo magulo po eh. Okay, so I am trying my best to simplify it para mas madali po ninyo maintindihan talaga. And then yung isa pa pong explanation dito ng Supreme Court kung bakit na-violate pa rin yung 1-year bar rule is because of the added discretion given po to the Secretary General and to the Speaker by their internal rules. Kasi wala po yun sa Constitution. Ang nakalagay lang sa Constitution, once a verified complaint is filed, it must be included in the calendar of business within 10 session days and must be referred to the Committee on Justice within 3 session days. Pero ang nangyari kasi sa internal rules ng House ngayon, meron pa silang step na i-file sa SecGen, tapos from SecGen, i-refer sa Speaker, which is dapat daw po as per the Supreme Court, wala yun kasi hindi yun siya discretionary action on any part of the House of Representatives. Dapat po upon file, automatic i-refer agad. So in short, it is a ministerial duty. So dun din po another explanation pa yan ng Supreme Court dito na yung added requirement na yon also considered as grave abuse of discretion. So yun yung, again, yan yung principle po na ina-explain ko way back pa. Itong mga added requirements nga basically contravene the very essence and spirit of the express provisions of our Constitution. Okay, so ang masasabi ko lang po dyan, hindi naman po bobo yung mga justices natin, diba? You have to remember, una-una po tatanda natin yung mga justices natin, mga abogado po yan lahat, diba? Na masyado na pong, or madami na pong legal experience talaga from their private practice before to eventually them becoming judges, tapos eventually siguro justices of the Court of Appeals or maybe even in politics, tapos eventually umabot po sa Supreme Court. In short, before po maging Supreme Court Justice, sobrang dami na pong judicial or legal experience ng mga yan. So more or less po yung mga naiisip natin na kung ako po tatanungin, minsan medyo mababaw para sa atin, siguro big deal na, pero in reality or in the legal side of things, medyo mababaw po yun. Kung tayo po naiisip natin yan, most likely po yung mga justices naiisip din yan because of their wisdom and experience. Yung mga Supreme Court justices po, before yan sila ma-appoint dyan, matatanda na po yan sila and they have decades of experience already from the legal side or even from private or government or public service. Okay? So anyway po, going back to the topic, eto, kinlarify din po yan ni Justice Leonen sa decision niya mismo. So makita po nyo, page 3, obviously sham complaints. For example, those that are not verified should be dismissed immediately even if endorsed. Complainants that are not properly endorsed by a member of the House of Representatives within a reasonable period should also be dismissed. These types of dismissal will not trigger the 1-year ban. Diba? So kung makikita ninyo, si Justice Leonen, he clarified na if very obvious na bogus sham complaint para lang matrigger yung 1-year bar, hindi yun masicircumvent yung 1-year bar prohibition pa rin. Again, this is because of the principle nga na what you cannot do directly, you cannot also do indirectly, diba? It is based on the principles of fairness, justice, and equity. Diba? In short, kung ano yung tama for all parties, yun yung dapat masunod. So kung very obvious na magpa-file ka lang to trigger this, hindi rin po yun dapat i-consider, diba? So alam din po yan ni Justice Leonen at of course ng mga justices na nag-agree po dito sa opinion na to. Okay, so siguro naman po yung next ninyong magiging argument naman dito kasi sinabi or yung binigay na example dito is para lang to sa mga not verified complaint or those that are not properly endorsed. So tandaan po natin, ang sinabi lang po dito for example, okay? Yun yung binigay na example in this decision but it does not mean na itong dalawa na not verified or not properly endorsed ay yun lang yung hindi magti-trigger ng 1-year bar rule. In other words, pwede yan i-argue at explain ng mga lawyers, ng mga congressmen na yung mga ganitong types of complaints or eventually po may mga future complaints na may hina na yung mga ganon should also or not trigger the 1-year bar rule. Okay? In other words, trabaho po yan ng mga abogado na later on, once may mga complaints na mukhang ano lang ba, mukhang basically gusto lang nila ipa-trigger. Tapos sila bahala na po basically yung abogado mag-review niyan at mag-determine. So, okay, so hopefully klaro po yun. So sana po wala namang mamiloso po sa inyo na it will only apply to not verified or not properly endorsed. Again, hindi po to limited to these types of sham complaints only because these are only examples given. Diba? Again, it can be argued na even weak cases should also not trigger the 1-year ban. Okay? So again, I will just reiterate, may kita po ninyo, alam po yan ni Justice Leonen at ng mga justices natin. Hindi po bobo ang mga Supreme Court justices natin. Sobrang hirap po magpa-appoint dyan, di ba? Kaya nga ang daming gusto magpa-appoint dyan tapos hindi natatanggap. So in short, let us just also respect our Supreme Court justices. Again, wag po tayo mabulag sa political biases natin, political fanaticism natin, tapos we will start attacking our honorable justices just because you are against their decision. Okay? So hopefully klaro din po yan. So ngayon, punta na po tayo dun sa nakalagay sa either sa thumbnail or sa description ko, yung mali daw yung facts ni Justice Leonen. Okay? Pero anyway po, before I will start explaining this, sa dami na po ng inexplain ko kanina, may kita naman po or nakita naman po nyo siguro na pwede talaga ma-argue na unconstitutional talaga yung 4th impeachment complaint. Diba? Because unang-una, there were clear violations of the internal rules of the House of Representatives mismo. Tapos there were also clear constitutional violations din po. So even if we assume na tama nga yung mga nagsasabi na mali yung facts ni Justice Leonen, pwede talaga siya ma-argue na unconstitutional kasi itong facts na to, hindi na po talaga to related dun sa mga inexplain ko kanina, pero despite them not being related, constitutional violations pa rin po lahat yun yung inexplain ko. Diba? Pero anyway, tingnan po natin kung ano po talaga yung facts. So ito po yung naging issue kasi dyan eh. Ito yung nangyari noong February 5, 2025. Tapos yung citation na ginamit po dito nila Justice Leonen is itong number 30, Victoria Tulad, Senate formally receives articles, blah blah blah, so on and so forth, available at ABS-CBN. Okay, yan, number 30. So yung summary po, at 4:47 PM of February 5, 2025, House Secretary Velasco transmitted the articles of impeachment to the Senate even without a plenary vote. Ito yung pinaka inaano nila ngayon, yung pinaka pinupukpok po ng mga pro-impeachment na even without a plenary vote daw. Tapos yung main nila ngayon, main contention is nagbase daw si Justice Leonen sa ABS-CBN news lang. Okay? So ito yung sa decision ni Justice Leonen. Ngayon ipakita ko po sa inyo yung concurring opinion ni Justice Hernando kung saan mas inexplain niya in detail tong mga nangyari dito. Tapos ipapakita ko rin po sa inyo kung ano yung basis doon ni Justice Hernando para kayo na po talaga ang makakonclude kung ano ba talaga yung tama o mali. Okay? Sara Duterte, Torreon versus House. Separate concurring opinion, Hernando J. Promulgated July 25, 2025. So makikita po natin yan sa page 3. So sinight po dito ni Justice Hernando mismo yung actual events. So basahin ko po para mas klaro talaga tayo. During the plenary session on the same date at around 3:37 PM, Secretary General Velasco read the 4th impeachment complaint and the first 3 impeachment complaints which were included in the additional reference of business. So at 3:37 PM, so on and so forth. Basically, inano lang nila yung actual words po na sinabi ni Rep. Dalipe, the speaker, anong SecGen. Tapos additional reference of business. And then ito, binasa yung mga title ngayon nung first 3 impeachment complaint and the 4th impeachment complaint. Tapos kung makita po ninyo, ang basis dito ni Justice Hernando, see also additional reference of business, House of Representatives, 19 Congress, 3rd session, February 5, 2025. Available at Docs Congress HREP online. In short, he based this po dun sa documents mismo available sa Congress website po. Then Records House, 19 Congress, 3rd session, February 5, 2025. In short, lahat po ng pinagbasihan ni Justice Hernando ay mga documents at records from the Congress na nakuha niya at yung mga pwede rin po i-download sa website ng Congress. So kung makita po nyo, di ba, number 5 and 6. So ito po yan, number 5. Okay? So anyway, kung gusto nyo po makita step by step to, basahin nyo na lang. This is in page 3 po ng concurring opinion ni Justice Hernando. And then number 4, page 4 na po tayo. So dito po, Rep. Dalipe, Mr. Speaker, today as provided for in our additional reference, so on and so forth. So basically, ito na po yung tungkol sa 4th impeachment complaint. Tapos pinapakita or ina-establish po dito ni Speaker at ni Rep. Dalipe na merong more than 1/3 yung nag-endorse dun sa 4th impeachment complaint. So makita po nyo, may we inquire from the SecGen how many members of the House verify and swore before him the impeachment complaint. And then ganyan-ganyan. And then sabi po ni SecGen, 215 House members. As the majority leader is recognized. Mr. Speaker, may we know what is 1/3? So yan, again, they are trying to establish that they complied with the 1/3 requirement. So sabi po ng SecGen, 1/3 of the total number of members of the House is 102. And the Speaker, the Secretary General has responded, the majority leader is recognized, and then yung nangyari next niyan, Rep. Dalipe Felipe. Mr. Speaker, for the record, in consonance with the Constitution on Article 11 on accountability of public officers, particularly Section 3, Paragraph 4, and pursuant to Section 14, Rule 4 of the Rules of Procedures in Impeachment Proceedings, so on and so forth, considering that the SecGen has certified at least 215 members had verified and swore, I move that the SecGen be directed to immediately endorse the same to the Senate. There is a motion to direct ganyan-ganyan. The chair hears none. The motion is approved. The Secretary General is so directed. Suspension of session. So kung makita po nyo, natapos na lahat, nagka-suspension of session, tas upon resumption of the plenary session at 3:45 p.m., the House approved the election of 11 of its members as prosecutors. So yan po yung mga nangyari based on the journal po ng House of Representatives mismo. Yung next question, was there a plenary vote on the impeachment complaint para i-endorse siya dun sa Senate? Wala po, di ba? Yung pinagawa lang po nila, pina-verify nila na may 215 House members ang nag-verify and swore as to that complaint. Iba po kasi yung plenary voting as to the fact na i-endorse yan at ipadala dun. Wala na pong nangyaring ganun. So dyan po ngayon nagkakaroon ng contention kasi after lang yan, meron daw more than 1/3 nag-endorse, and then from there, in-endorse na may nag-move lang tas pina-endorse. Wala ng plenary voting basically nangyari. So again, kayo na po bahala mag-conclude kung ano ba tingin niya dito. Was there a plenary voting or no plenary voting? So as per the Supreme Court, walang plenary voting na nangyari. And again, ito hindi na po to fake news or hearsay because this is from the records of Congress na mismo. Tapos inisa-isa talaga ni Justice Hernando yung mga steps na nangyari. Okay, so kung ako po tatanungin, this is also not a plenary voting if you ask me. Kasi hindi po ganyan pag plenary voting. Ito po based from my experience sa Congress ha. Pag nagbobotohan po kasi kami ng bills, isa-isa po talaga yan tatanungin. Abayon kung yes or no. Dito kung makita po nyo, wala. Ang ginawa lang, there is a motion to direct the SecGen to immediately endorse to the Senate. The chair hears none. The motion is approved. The Secretary General is so directed. So if you ask me, that is not a plenary voting. A plenary voting po is a voting na isa-isa tatawagin talaga yung members ng Congress. This is from my experience po kung paano kami nag-a-approve ng mga bills before on third reading. Okay, so hopefully klaro din po yan. It will not change the fact po na there is a potential grave abuse of discretion based on everything that I already explained dun sa mga clear violations po na nangyari talaga dun sa internal rules ng House and then dun sa constitutional provisions. So kung ako nga po tatanungin, yung tingin ko po dito, this is actually not very material itong argument na to. Kasi kahit wala po, kahit tanggalin to, klaro naman na hindi nasunod yung due process provisions not only of the Constitution but also of the internal rules of the House of Representatives. Diba? Nakalagay doon, they are following the Francisco ruling. Ipakita ko na nga lang po ulit para sigurado talaga tayo. So ito po, pakita ko na lang ulit. The Supreme Court decision, Francisco. So mode of initiation, this is Rule 2, Rules of Procedure Impeachment Proceedings, House of Representatives, 19th Congress. Diba? So a verified complaint or resolution of impeachment filed by at least 1/3 of all members of the House shall be referred to the Committee on Justice. Diba? Shall, referral, Committee on Justice. Ito yan, yung ginawa nila. And then after na sa Committee on Justice na yan, papasok na nga tong due process clause ng internal rules nila, finding probable cause, like what I explained earlier. So kahit nga po hindi in-explain to ng Supreme Court or hindi pinagbasihan ng Supreme Court yung Bill of Rights, yung Article 3 sa 1987 Constitution, nakasulat na po yan mismo sa internal rules ng House na hindi rin po na nasunod, di ba? Kasi upon motion po dun sa plenary, diniretso na nila refer agad sa Senate yung impeachment complaint that was verified or endorsed by at least 1/3 of all members of the House of Representatives. Okay? So hopefully klaro po yan. So anyway, ang final remarks ko lang po talaga dito is sana matigil na talaga yung yung bangayan, yung mga political messaging, mga political biases natin, political branding. Kasi kung tatandaan po natin, the respective parties in this case have already filed the appropriate pleadings, diba? Yung aggrieved parties, they have filed their motions for reconsideration. And then currently, wala namang kailangan, or meron palang directive kala Vice President Sara na mag-reply din or mag-comment dun sa motion for reconsideration po na final ng House of Representatives. Pero yung problema po kasi, despite na ginawa na po yun ng lahat ng parties, ang dami pa rin mga media interviews, media statements that are clearly attacking the Supreme Court. And ako po as an officer of the court, hindi po pwede sa akin yun, di ba? Kasi una-una titingnan po natin, even the IBP mismo agrees with the decision of the Supreme Court. Panoorin po nyo yung interview ng IBP National President. Personal opinion niya, agree siya sa Supreme Court, and the IBP as an institution also agrees with the Supreme Court. Okay? Pero tandaan po natin, hindi ko po sinasabi na you cannot question the decision of the Supreme Court ha. Ang sa akin lang, let us give respect to the Supreme Court and to our Supreme Court justices, okay? Huwag sana tayo maging spoiled brats na porkit natalo tayo sa kaso, ngayon gusto na natin magalit lahat ng mga people around us dun sa Supreme Court. Huwag naman po sana ganyan because that is very unfair, di ba? So in short, maging patas lang po tayo, sundin po natin yung mga Supreme Court decisions at present.
So yan po, no? Yan po ang diniscuss ni Attorney Neil Abayon. Sana po wag po kayong magalit sa desisyon ng ating Korte Suprema, no? So wag po tayo maging bias. So tapos po, yung po hindi pa po nakapag-subscribe sa ating channel. Ayun po, sa ilalim po ng ating video sa bandang kanan, may logo po doon. Huwag niyo pong kalimutan pindutin para makapag-subscribe, no? Ito po kasi patapos na rin po ang ating video. Malapit na po. Sa minuto na lang po. Tapusin na po natin, no? Ito na.
Ito po kung ma-overturn, edi lahat po ng sinabi ko dito basically kinain ko, 'di ba? Kung mag-overturn yung Supreme Court sa motion for reconsideration. Pero at present po kasi ito yung decision, 'di ba? So kung ito yung decision at present, respetuhin po sana natin despite of our political affiliations or biases, 'di ba? Wag po tayong mag-incite to sedition, mag-incite na magalit yung taong bayan sa Supreme Court. Di ba? Wag po tayo ganun, tapos tatawagin Supreme Cuddler, tapos Sarah Court, yung mga ganyan ba? It's very unprofessional and very, in other words, in the simplest term I can say it, para po tayong mga spoiled brat na natalo, para tayong sore loser basically. Diba? Ayaw naman po natin yung ganun. Okay? So hopefully klaro po yan. If you like more legal educational videos, may lalabas po yan dito na i-recommend ni YouTube algorithm sa inyo. And if you want to be notified kung may bago po tayong upload, subscribe lang po kayo. And until next time, see you all. Bye-bye! Peace Peace to all the liberals ba?
So ayun po, no? Natapos na po ang video ng ating attorney na i-discuss ni Attorney Abayon. So maraming salamat po at sana po huwag niyo pong kalimutan yun, mag-subscribe at sana po panoorin niyo po ang ating mga ibang video. Shukran.